Very, very specific. We spent a lot of time trying to suss out what, frankly, are very alarming deficiencies in the discovery that was provided to the defense at the time of trial. Those are the items we're requesting. I agree it should not take 180 days for them to locate those items and provide them to us. The defense was entitled to those at the time of trial. Mr. Peterson has been waiting 20 years to find some of these police reports and audio recordings and video recordings that should have been provided.
Thanks for being with us. This is Court TV Live. We are your front row seat to justice. I'm your host, Julie Grant. And all through this hour, we're bringing you unaired portions of Scott Peterson's hearing on Tuesday. Convicted of murdering his wife, Laci, and their unborn son, Connor, Peterson's currently serving a life sentence while fighting for a new trial. Now, this time, he's got some help from the Los Angeles Innocence Project. And in this first portion you're about to see, Peterson's defense team is requesting access to evidence materials which were gathered during the initial investigation over 20 years ago.
It was represented by the Modesto Police Department that Ms. Jackson was going to be subjected to a cognitive interview and not a hypnosis. And our information, based on the interview Gary Ermoyan had with Ms. Jackson on January 17th, is that she stated to him that she was being asked to go to the Modesto Police Department the following day for hypnosis. As the court may recall, the individual who performed the hypnosis was not qualified to do so, and therefore all of Ms. Jackson's testimony became unavailable at the time of trial. If there were any records within the police department as to how this interview was going to be conducted, by whom, why, whether this person was qualified, we would like those provided to the defense. If Your Honor would like, I can just say that with respect to B, C, D, and E, the other witnesses who reported to Modesto Police that they saw vans either on Medina that day or, in the case of Kim V, nearby. These individuals have all, we have been unable to interview Ninev. We have interviewed Linda and Kim V. We have not been able to interview Sean N. We don't have a basis to believe that the police did interview them, but if they did, we would like those reports.
Okay. Then, Ms. Franks, if you want to respond to the items contained in A21, given the comments just made, I don't think you need to respond to B, C, D, and E subdivisions, but if you want to talk about the A subdivisions, you may.
The only thing, comment, Your Honor, is some of these requests that we've already spoken about are duplicates, and we can discuss that when we get to the duplicates below. For example, D is a duplicate request from, we can get to that below when we get to that whole slew of requests in 28. But comments from the people is Diane Jackson's testimony was not unavailable at trial. It actually came in by Judge DeLucchi for the truth of the matter asserted.
The pre-hypnosis testimony or the pre-hypnosis statement was admitted before the jury, but nothing post-hypnosis was admitted because of the hypnosis.
Correct. And defense cites to the Bates pages that they're relying on to deal with all of those witnesses that they just referenced, Diane Jackson, Linda, and Naive, as well as Sean. So without them pointing to something specific like they did in number 1 or 20D, they have everything. And lastly, the very first request, 21, they're asking for an accounting. They're demanding what investigative steps were taken, exactly what they're not permitted to do. With that, we submit.
Okay, thank you. Comments on the next?
Item 22, Your Honor, we are withdrawing our request for A, B, and C because we now know that those items were not collected from the Medina's home as part of the burglary investigation.
Okay.
With respect to D photographs, and we do not have any photographs that were taken during the investigation of the Medina's home.
Okay. And do any of the narrative reports or any of the discovery that you do have indicate photographs were taken?
Susan Medina indicated to us in her interview, and I believe in her declaration,
So you have a witness statement saying photographs were taken during the investigation.
And fingerprint examinations, as well as there was a shoe print on the back door. I don't know if that was photographed. If it was, we don't have it. I do not know if we don't have any lab reports or forensic reports, so I don't know if that was conducted. If it was, we would like those produced. And if anything related to the Medina burglary has been destroyed, which the prosecution has alluded to, we would like a sworn declaration by an evidence clerk or custodian of records confirming under penalty of perjury that any evidence related to the Medina burglary that was collected has since been destroyed.
So I think we got through subdivisions D and E. I don't know that you commented specifically on the rest of it, but F, when you say hairs, fibers, and other trace evidence collected from the Medina home, then we get into there's a different process for access to physical evidence if it exists. What is it specifically you're asking under 1054.9? What is it specifically you're asking for under F?
Susan Medina indicated to us in her interview that evidence technician Doug Lavelle and Joyce Smith came to their home on December 26th and were conducting a search for physical evidence. We do not have any reports of any evidence that was collected from the Medina's home during that investigation by those individuals. If any evidence was collected and or subjected to forensic testing.
Right, that's E, where you say fingerprint examination reports by and or any other DNA, biological, or forensic, so reports conducted on that. F is hairs, fibers, or other trace evidence collected from the Medina home. Are you asking me to let your investigator go look at that stuff if it still exists? Like,
No.
What is the request under F that's different from E?
Okay, withdrawn, Your Honor. F is withdrawn.
Okay, thank you. Then G, then would be essentially the requests for any testing that may have been conducted on any of those items, which is self-explanatory. H, the reports for any such testing conducted, also self-explanatory. And then I is destruction orders in the event that evidence no longer exists.
All right, Scott Peterson trying to get a new trial with the help of the Los Angeles Innocence Project, which is not affiliated with the National Innocence Project, not the one that Barry Scheck started. This is a small group. They're advocating for him. We'll see what happens. Let me bring in my guests now. Let's talk a little bit about Scott Peterson, whether it's actually a possibility that he could have a new trial after all these years. I have with me on the program high-profile criminal defense attorney and former prosecutor Mark O'Mara and retired DEA supervisory special agent Michael Wilhite Sr. Great to see you both. Okay, Scott Peterson, does he have a chance here? I keep getting the question from people, is this realistic? Is this a realistic shot? What's going on here? Are they grasping at straws and wasting the court's time? Mark O'Mara, I want to pick your brain about that. Your thoughts, please.
So it's been a real circuitous route for Dale Scott for the past 22 years. And it's going to be very interesting when the Innocence Project does get involved, because they don't take on every case. It does give me a little pause to wonder what they're finding. And my default is not that we keep trying every case over and over and over again. We do need to have finality, but if there really is evidence out there that was not, if collected and not analyzed, and if there is a legitimate nexus to now the existing questions as to whether or not the burglary that day has something to do with it, whether or not there really is forensic evidence tying Scott, then maybe we do it one last time 20 years later. Maybe we give the defense that evidence, let them spend their time with the lab analyzing it. The judge did say you get one, the duct tape. Let's go through it one last time, potentially. But I agree that Laci's family is also not resting for the past 20 years because of this ongoing case. And we do have to have finality soon.
Yes, thank you for bringing that up, Mark. Really, thank you. The victim, Laci Peterson, the victim, Connor Peterson, the baby, the unborn baby killed here. For all these years, you're right. It's always something with this guy. I mean, I think he's really lucky he's not still on death row. We know initially he was sentenced to die for his crimes, and that was overturned through the years and the legal process playing out. Michael T. Wilhite, you know, as an investigator, looking at the evidence, essentially Peterson is saying, you know, oh, investigators got this wrong. I'm innocent. I'm not the guy. What do you say, looking at the evidence objectively?
Well, objectively, I mean, again, you're talking over 20 years. This is truly a historic case. No matter what, they're going to the system is built for due diligence to be done. So if he's claiming, if his side is claiming that, hey, you know, there's a possibility that, you know, there's evidence out there that could free me, or at a minimum get me off of death row, whatever, then they need to, you know, he has, just like the victims had, the victims have rights, he also had, the defendant also had rights too. So he has the right to put forth an argument and say, hey, listen, take a look at this. Take a look at this evidence. As, you know, take a look at this new angle or whatever, and see what happens.
Mm-hmm. Right. You know, he has rights. He's exercising his rights, certainly. Is this justice? You know, will Laci and Connor have the finality, as you said, Mark, if he does get a new trial? And I know we're steps away from that, because the first steps are whether certain pieces of evidence will be tested. The court has to make rulings on that. Mark O'Mara, as you've seen this case progress throughout the years, and now here we are, 20 years later, Scott Peterson still saying he didn't do it. What are the important things you think the public can perhaps take away from this? For anybody sitting at home going, I thought this case was put to bed. I thought it was done. What would you say to them, please?
So I have a slight frustration with it, and that is that we get attacked in the criminal justice system for this lack of finality, right? Criminal defense attorneys get clients off when they're definitely guilty, and then the appellate courts let them off. And I get that, and I understand that. So I do have a frustration that 20 years later, the general public is looking at this going, this is never going to end. The system is not to be trusted. Only the victim's family is hurt by this. And I get that. And we do have to have that finality, right? You have 30 days to appeal a sentence. If you don't do it, you're done. If there really is evidence like this that was hidden or just by true negligence not gotten, then yes, the defendant deserves his day in court or her day in court. But I am frustrated by the fact that we have a system that's already being sort of attacked from the inside and the outside. We do need to rebuild trust, and deference to Scott Peterson. I'm a criminal defense attorney. This needs to be over soon, because we need to rebuild the trust in an already attacked system.
Mm-hmm. You're right, Mark. We need trust rebuilt in our criminal justice system. That is for sure. What a treat it has been today having you back on the program. Mark O'Mara, we missed you so much. Always great having your insight.
I'm back.
You're back. It's a party. Come back again soon, please. I know we need to let you go and get off to court today, but we'd love to have you back anytime. Thank you kindly.
Great to see you again. Be well.
Thanks, Mark. And Michael Wilhite's coming along with us. Want you to do the same, please. We're going to hit a break. When we come back, we got more of Scott Peterson's hearing. You'll hear what they're arguing next. Did a customs agent commit cold-blooded murder?
Marsha Thompson is accused of fatally shooting her husband as he's lying on a couch. She's claiming self-defense, alleging that Terry Thompson repeatedly threatened to kill her.
So what really happened inside this home?
Now a jury will decide the fate of this law enforcement officer.
And Court TV will bring it all to you.
The abused wife or murderer trial. Live coverage today, only on Court TV.
So glad you're with us this morning here on Court TV Live. Welcome back. I'm your host, Julie Grant. We're getting ready for the abused wife or murderer trial to start back up at 10 a.m. Eastern time. So we're going to take you live to Florida then. Today could be the day that the state rests its case in chief, and then it'll be the defense's turn to put on evidence if they so choose. And we're getting very strong indications that the defendant may testify. That former Border Patrol agent may give testimony about why she shot her husband on on that dreadful day back in August of 2019. So stay tuned for that in about 45 minutes or so. In the meantime, we are showing you footage that hasn't aired yet from Scott Peterson's hearing on Tuesday. That's right, the convicted killer, currently serving a life sentence after his death sentence was overturned, is still fighting for a new trial, still proclaiming his innocence. He's got some help from a local group, the Los Angeles Innocence Project, not affiliated with the National Innocence Project. And in this portion you're about to see, both sides continue arguing after the defense's request for evidence discovery during the first murder investigation. Let's take a listen.
Defense cited to Bates page 2385. So they do have a report that indicates what was done at the house. The statement that we don't have a report is not exactly accurate. They do have a report. And Lavelle did author that report where he indicated that he fingerprinted and pulled a partial latent print off of the door, and later that evidence tech did a comparison and confirmed that that fingerprint belonged to the Medina's daughter. So that fingerprint was the only print that was pulled out of the residence. There is no indication in that report that they took anything else other than the fingerprints and the 3 envelopes that Miss Medina believed were the burglar may have touched. And subsequent to the testing for the fingerprinting on it, those envelopes were taken and destroyed with her permission because of the toxic chemicals in it. That's also written in Lavelle's report. But outside that, it does not say anything about photographs. Defense cites to Miss Medina's declaration. If they could point the court and the people to where in her declaration it indicates that photographs were taken. We have no other basis to show that any photographs were taken. Or additionally, all of the anything that was tested forensically, since the only thing from the house was specifically the latent print that was recovered and those 3 envelopes that were subsequently destroyed, Your Honor.
So in terms of the testing that was conducted identifying the latent print and the destruction of the envelopes after testing chemicals were applied to those, are those things that are in defense possession, or is this a file reconstruction issue, Ms. Mitchell?
It's a file reconstruction issue.
So you don't have those things?
Correct.
Okay.
May I just bring a comment? It is that Bates page that they're citing to. I'm reading off of.
Okay, so I didn't hear. Which Bates page did you reference?
I believe it.
In my notes, I've got a Bates page for the last, but I mean, I've written it down. So
it's in their informal letter, and it is 20385.
Okay, Ms. Mitchell. You have that?
I do not have that in front of me.
Okay, can you look and see if you have it? Because again, I don't want to write an order that requires the prosecution to give you a bunch of material that you already have in your file and you don't need.
What I have in my notes, Your Honor, is that photographs of the Medina's doors, a chair, several boxes and containers, envelopes found inside the Medina's home and possibly elsewhere were taken by evidence ID technician Doug Lavelle. They were processed, collected and processed. We do not have any of those reports. I can look for this Bates document out of Rick, Your Honor, and if there's anything to add, I will look for them.
All right, and Ms. Rice, in terms of the representation you just made that the latent print was identified, was that contained within the Bates page that you just read from?
It is, Your Honor. As far as that goes, I can can cite you. It was ID Tech Joy Smith that compared and confirmed that the print belonged to Medina's daughter, Rhonda Medina. That is all located in that Bates page.
And that Bates page is a report of whom?
It is from CSO Doug Lavelle.
Okay, so Lavelle wrote whatever report contained Bates page 20385. He indicated that ID Tech Joy Smith did the comparison and that the latent print was the Medina's daughter's print.
Yes, Your Honor.
Okay. And that Bates page does not indicate that there was what about the envelopes that you talked about?
It indicates specifically, additionally, only evidence collected was 3 envelopes, which were later destroyed after Lavelle processed them with nihydrin.
Okay. And that was also contained in Lavelle's report that was Bates page 20385.
Yes, Your Honor, and he also actually provided it in Disc 4 as well in our opposition because we referenced it to the court.
Okay. I will take a look at it during break too. Thank you. All right, then that brings us, I think, to A23.
So as I mentioned yesterday, Your Honor, we're withdrawing our request that the confidential informants' identities be revealed. We're asking for the content of any statements these informants provided to the officers listed in 23A through F. The Officer Helton's report at Bates 2391 indicates that he received information. Officer Helton's report at 2392, same. Detective Stow's report at Bates 20361 and 20365, same. Agent Brody's report at 20397 and Detective Cloward's report at 20393. If any of the information received from informants relating to who they believe or had information was responsible or may have been responsible for the Medina burglary in addition to Mr. Todd and Mr. Pierce would have been discoverable at the time of trial.
Tell you what, Scott Peterson's team has been very thorough here. They're leaving no stone unturned, trying to get him a new trial. Will it happen? We'll have more from his hearing, more that you haven't seen. We're showing the unaired footage this hour as we're getting ready for the abused wife or murderer trial to start back up in just about 30 minutes. Thanks for being with us this morning here on Court TV Live.
Is that correct, Mr. Peterson? You're pleading not guilty to the 2 charges of murder plus the special denying the special allegations?
Absolutely. That's correct, Your Honor. I'm innocent.
Oh, that was over 20 years ago when Scott Peterson said that. Now he's a convicted killer and still saying he's innocent. And he's getting some help from a local group called the Los Angeles Innocence Project. And they are going to the court trying to find grounds for a new trial for him. Peterson's defense team is requesting access to more than 600 pieces of case evidence from the initial murder investigation. Let's go back into the courtroom now.
So the Bates pages that you have in terms of Officer Helton's report, Detective Stow's report that are identified in your motion, they do not. They simply say, I received information from a confidential informant and based on that I went and did X, Y, or Z, or do they specify, I received the following information from a confidential informant that then led me to go do X, Y, and Z?
With respect to, I think this is coming up in a subsequent request. So 2392, Detective Stow stated that Mark, just says Mark, who recently raided in the park was possibly involved in the burglary. Officers offered that this was possibly Mark Thomas.
Okay.
That information, we believe, the next paragraph states that confidential, reliable informant informed me that and related that the subject may be the same by the same name of Sanjeet, an Indian male, does 459s all the time. He will contact me when he gets additional information. The informant said he believes Sanjeet may have access to or drive a white van. We have no follow-up reports on this. We don't know. This is all we have.
Okay, so for the one you just read me where, confidential reliable informant said, basically, I know a guy named Sanjeev who does a lot of burglaries and has a white van, I'll let you know if I find anything else out. Is there any reason that you have to believe, based on either any of your investigation or anything that is referenced in the file, that that confidential reliable informant actually provided any information beyond what's in the statement? Like, why do you believe that more of this exists?
Because further down on 2392, it states that there were 3 tactical patrol unit vehicles used during this investigation, which we discussed yesterday, and that these vehicles, at least in the instance of Mr. Peterson being arrested and driven to Modesto, are wired for recording. We have had a recurring issue in the case whereby written reports, like the one we're looking at here, 2392, do not fully set forth the information that is found on the recordings. We just discussed that earlier this morning, Your Honor, with respect to the polygraph examination, wherein Mr. Todd stated on the video recording that he was a daily drug user. That information was not captured in the written report that the polygraph examiner provided and that was produced to the defense. If these officers who were investigating the burglary are riding around, which I believe is in another report, I don't have it in front of me, with confidential informants looking for the property that was stolen from the Medina's home and gathering information about where this property might be located and who may have been responsible for the burglary, that is not captured in the written reports we have. That is another reason we were asking for all recordings with these individuals that may include additional information with respect to that burglary, who committed it, and when.
All right, thank you. Comments by people?
Yes, Your Honor. First, to address the speculation that all of the MPD cars are wired for recordings is not accurate. When Scott Peterson was arrested on April 18th, Modesto Police Department drove down to San Diego. They specifically put, back in the day, they would have audio cassette recordings, and they placed an audio cassette recording in the car from San Diego to Modesto for an 8-hour transport. They knew that they were arresting Scott Peterson. They wanted to make sure to capture any statements that he said. Defense knows that exists because they have that recording, including when he was told that he confirmed that it was Laci and Connor's body that washed ashore 4 days earlier, and then proceeded to ask for his meal at In-N-Out. Outside of that, there's no other evidence that any of the other cars are equipped or were equipped with any type of recording devices. M-bars at that time didn't exist, essentially. So defense is again speculating that these cars are equipped with this without proof of anything other than she's jumping to conclusions based off of that audio recording, which was also utilized when he was transported, as I said yesterday, to the hospital to take a search warrant execution on him. But as pertaining to this Medina burglary, there's no evidence that any of these audio recordings exist.
All right, so we know that the Los Angeles Innocence Project has been really, really diligent. One of the representatives from the group told the court as part of this that they've reviewed 10,000 different tips, 10,000. This case, it took America by storm when it happened. It was like the unthinkable. You know, this beautiful pregnant woman disappears right around Christmas time. I mean, it's horrific. And then the ending, I mean, that it's Scott Peterson who's convicted. The jury found him guilty. They found that he murdered Laci, murdered their unborn baby, Connor. And now he's still after all this time, saying he's innocent. Let me bring in our guest. He's a retired DEA supervisory special agent, also the owner of MTW Consulting, does law enforcement consulting and training work, Michael T. Wilhite Sr. Michael, I understand that he has rights, and I understand that his lawyers and the Los Angeles Innocence Project are working hard, and there are people who still believe in his innocence. I just can't help but thinking back to something really simple. We know that Scott Peterson was cheating on Laci, his wife at the time, and told his girlfriend 15 days before Laci went missing that he had lost his wife and would be spending the first holiday without her. Your thoughts on that?
Well, like I said before in the other segment, Julie, yeah, he has to. I mean, his team has to, look under every stone and turn every rock, as far as trying to get this guy off. You're rolling the dice. They're rolling the dice, of course, but it is what it is. I mean, he for the most part, holy cow, over these 20-year period during the trial and everything, he's pretty much did it, in my opinion, looking at and following this case, he did himself just by opening his mouth.
Right. Oh, yeah. I mean, there's recorded calls with Amber Fry, his mistress. I mean, he is cheating on his pregnant wife. That's what he's doing. So, you have a scumbag move right there, and then he's telling her that she's dead. Telling that she's dead. And this is 15 days before she disappears.
Before she disappears, correct.
Yeah. I mean, and so, when all this is happening and, we got to get a tip and go back to the burglary. Yeah, investigators looked at the people who did the burglary. They looked at them 20 years ago and they vetted them and said, yeah, the burglary at the house diagonal from the Petersons, yeah, didn't have anything to do with this. I mean, let's remember the simple things. Who had the motive to murder her? Him.
Right.
Michael, do you find that sometimes cases aren't all that complicated, but sometimes they can be overcomplicated by, perhaps people just overly interested in a case?
Listen, Julie, I'm known for telling my family members, this friend says, this thing we call life, it's not complicated. It isn't
Preach, Michael, preach.
Okay? What makes it the complication come in. The complication come in when you got people involved. Us.
Yeah. Yep.
But life itself isn't complicated. Investigations isn't complicated.
Right. And over your years, I'm sure, have you found that most people's problems bear their own fingerprints?
It's most people's problems, and that includes me too. I'm part of that. I'm part of that genre.
I know. I hear you.
The problems are self-induced.
Yeah, we got to self-reflect on the problems we're causing for ourselves. And Scott Peterson, boy, oh boy, he got himself jammed up.
In regards to Scott, he's rolling the dice. They have to let him roll the dice, Yeah. Let him roll the dice.
Yeah. We'll see. I think he's lucky. He's lucky he's not on death row still.
He is lucky. He's very lucky.
He could be on death row. Remember, that jury sentenced him to die for his crimes. Michael T. Wilhite, so great having you on the program. Thank you for all of your analysis and great insight. We'll see you soon.
Thank you for the opportunity, Julie.
Of course. And we're going to hit a break. When we come back, we still got a little more from the Peterson hearing. What do you think? Do you believe in his innocence? Hit us up on social media. Let us know. And we're getting ready for the abused wife or murderer trial to start up in our next hour. Did a customs agent commit cold-blooded murder?
Marsha Thompson is accused of fatally shooting her husband as he's lying on a couch. She's claiming self-defense, alleging that Terry Thompson repeatedly threatened to kill her.
So what really happened inside this home?
Now, a jury will decide the fate of this law enforcement officer.
And Court TV will bring it all to you.
The abused wife or murderer trial. Live coverage today, only on Court TV.
State of California versus Scott Peterson. We, the jury, in the above entitled cause, find the defendant, Scott Lee Peterson, guilty of the crime of murder of Laci Denise Peterson.
Remember that big crowd cheering after the conviction was announced for Scott Peterson? Fast forward now, we're going 20 years away from that moment in time, and this guy is still proclaiming his innocence. We're airing for you some footage we haven't aired yet of his quest for a new trial in that big hearing that helped out on Tuesday. Now, in this portion you're about to see, both sides are arguing about the possible admissibility of some statements made by a jailhouse informant.
We're asking for any other information. This individual, who we have determined is Ralph G., received a reward for the information he provided. We're asking for any criminal history records that are in this investigation file with the Modesto Police Department, including the arrest report for Mr. X, Ralph G., on January 3rd, related booking photos, any custodial statements he may have made pursuant to that arrest, audio or video recordings or transcripts thereof concerning his knowledge of the individuals involved in the Medina burglary and or Laci Peterson's disappearance. E is the charging documents related to his arrest on January 3rd. The day after Stephen Todd and Glenn Pierce were arrested, Ralph was arrested for receipt of stolen property. He received a plea deal. That the proceedings around his plea are records we would request. We have been unable to find them at the courthouse. We have personally gone and looked for them at the courthouse. We would like the factual basis for his plea, any abstract of judgment related to his plea, essentially any information concerning whether or not he himself was involved in the burglary, any information that the Modesto Police Department has concerning any investigation they did into his role or possible role in that Medina burglary. Mr. X, Ralph G., was right about Stephen Todd being involved in the Medina burglary. He also mentioned that there was an additional suspect named Mark he believed was also involved in the Medina burglary. We do not have any information that this was followed up on by police, that this individual named Mark was ever identified, or any interview reports with Ralph G. whatsoever. We would ask that if those exist, they be provided. They should have been provided at the time of trial to the defense.
And this is the theory for why you think they should have been entitled or provided to the defense at the time of trial, is the theory that they're exculpatory.
Yes.
In what way?
Because it is further evidence that there were more than two individuals responsible for the Medina burglary, that there is information in the possession of the Modesto Police Department related to the identity of additional suspects who may have been involved in the Medina burglary, and if there is such an interview with this informant, the date that the Medina burglary occurred.
Yes, Your Honor. In one breath, the defense is saying we're withdrawing our request to find out the identity of the informant.
No, status.
The status of the informant, whether or not he is an ongoing informant.
Okay. 2392, which is what they're relying on, is Sergeant Pelton's report, which indicates that the person is not identified, is the one that gave reliable information to the police, which led to the search warrants. The defense is completely speculating, and it's attached in one of their declarations by an investigative journalist who is sending a letter to a Ralph G. in jail or prison, something to that effect, trying to find out if he was the informant and trying to find out if he received a reward. They're trying to get around doing the privilege by asserting that this is the informant and looking for confirmation without procedurally following what they need to do. Second, if this is a third-party culpability claim, they have not met their burden by any means, and they haven't shown how this would fall under any of the 1054.1 categories, because Ralph G., whoever he is, did not testify, and anybody related to Ralph. We don't even know who Ralph G is at this point, but he did not testify at trial. They did point the court to, or direct the court to, I guess, booking records or some kind of records that the defense actually has, because they must have been doing their own investigation into who they think is Ralph G. So they thought whatever records that they generated on their own through their own investigation, and nothing that they're pointing to within the discovery would indicate that there's anything more, including failure to follow procedures as far as the confidential informant.
All right, so there you have it. Now we're going to update you on when the judge issues her written ruling on the Peterson DNA evidence.